Be ready. Start. The gist of this action is negligence, which is the want of ordinary care, and the burden of proving the negligence of the defendant rests upon the plaintiff. Stop. If there was no negligence on the part of the company, your verdict should be for the defendant. Stop. Even if there was negligence on the part of the defendant, yet if the negligence of the plaintiff contributed proximately to the accident at the time thereof, the plaintiff cannot recover. Stop. In such case, the plaintiff would himself be guilty of contributory negligence, and where there is such negligence, the law will not attempt to measure the proportion of blame or negligence to be attributed to each party. Stop. Contributory negligence has been defined to be the negligence of the plaintiff or of the person on account of whose injury the action is brought, amounting to a want of ordinary care and approximately contributing to the injury. Stop. The relation existing between the defendant and the plaintiff at the time of the accident was that of master and servant, and the primary duty imposed upon the defendant towards the plaintiff in the course of his employment by reason of this relation was to furnish him reasonably safe tools, machinery, and appliances with which to work. Stop. The tools or machinery used need not be of the safest, best, nor of the most improved kind. Stop. It is sufficient if they are reasonably safe and adapted to the purpose of the employment. Stop. If the master fails to observe this rule of law and injury results to his servant from such failure, he becomes liable, therefore, on the ground of negligence. Stop. In the performance of this duty, the master must use all reasonable care and prudence for the safety of the servant, having regard to the character of the work to be performed. Stop. Such care must be in proportion to the danger of the employment. Stop. The servant has the right to rely on the master for the performance of this duty without inquiry on his part. Stop. The servant assumes no risk whatever as to such primary duty at the time he enters upon his employment, but he does assume all the ordinary risks incidents to the employment, such as are patent, seen, and known, or which may be seen and known by the ordinary use of his senses. Stop. And he is required to exercise due care, and caution in the course of his employment to avoid dangers and injuries for the master, having performed the primary duties required to him, is not an insurer of the safety of his servants. Stop. It is the duty of the master also to maintain said tools and machinery in a reasonably safe condition so long as they are continued in use.